Hello friends, in today's session we are going to discuss the case of Ms.J.Jayalalita versus Union of India. Let us first understand this case in brief. The main issue in this case was the constitutional validity of Section 3 and 4 of the Prevention of Corruption Act 1988. Special judges were appointed to hear corruption cases against Ms. Jayalalitha. The Madras High Court held the appointments to be constitutional, but the central government challenged this. The Supreme Court upheld the appointments made by the state government and quashed the notification issued by the central government. Thus, the Supreme Court affirmed the validity of the Act and the appointment of the special judges while dismissing all other appeals. Now, let us study this case in details. Answer: Ms.J.Jayalalita and others appellant versus Union of India and others respondent. Reference A.I.R 1999 SC 1912. Subject: this case pertains to Section 3 and 4 of the Prevention of Corruption Act 1988, under which both the central and state government are empowered to appoint special judges for the trial of cases under the said Act. Facts of the case: Ms.J.Jayalalita served as the Chief Minister of the State of Tamil Nadu from 1991 to 96. In the subsequent State Assembly election held in 1996, her party AIADMK was defeated and the DMK party came into power. Following the elections, criminal proceedings under the Prevention of Corruption Act 1988 were initiated against Ms. Jayalalitha, her cabinet colleagues, certain legislators of her party and some government officials. By 26 March 1997, approximately 38 FIRs were registered, primarily related to the acquisition of disproportionate assets. Considering the public importance, sensitivity and need for the speedy disposal of these cases, the government of Tamil Nadu decided to appoint 3 special judges of the rank of district judge to conduct day-to-day hearing. The state government sought concurrence from the Madras High Court and upon receiving approval established 3 additional courts in the premises of the City Civil Court, Chennai, through an order dated April 17, 1997. Thereafter, by notification dated April 30, 1997, the 11th, 12th and 13 additional city civil and session judges were appointed as special judges authorized to hear a total of 41 cases against all the accused. High Court's decision: the constitutional validity of the notification dated April 30, 1997 and the Section 3 of the Prevention of Corruption Act 1988 was challenged by Ms. Jayalalitha and others before the Madras High Court. The petitioners argued that Section 3 of the Act and the said notification violated Article 14 and 21 of the Constitution. The Madras High Court rejected the challenge and held that Section 3 of Prevention of Corruption Act is constitutionally valid. The court clarified that the appointment of a special judge cannot be equated with the establishment of a special court. When the government appoints a special judge for a specific group of cases, the trial is still conducted under the due process of law and judicial principles. Hence, it does not constitute any arbitrariness or violation of Articles 14 and 21. The High Court further upheld the validity of the notification dated April 30, 1997 regarding the establishment of 3 additional session courts in Chennai and the appointment of the respective judges or special judges. Additionally, the court ruled that the purpose and scheme of the Prevention of Corruption Act provides sufficient guidelines for the exercise of power under Section 3 and therefore the discretion vested in the state government is not unguided, unregulated or absolute. Subsequently, the central government exercised powers under section 3(1) of the Prevention of Corruption Act issued a notification dated February 5, 1999 appointing the same three judges as special judges for Chennai. The central government contended that when more than one special judge is appointed in a particular area, only the central government has the exclusive authority to decide which judge shall try which case. Therefore, the state government's allocation of cases and appointment of special judges under the notification dated April 30, 1997 was not legally valid. The Advocate General of Tamil Nadu challenged the central government's notification dated February 5, 1999 before the Madras High Court, which quashed the notification on the ground that the issue of the state government's power to appoint special courts under the Act was pending before the Supreme Court. The High Court observed that the determination of whether the central government had the authority to issue such a notification could only be made by the Supreme Court, not the High Court. Supreme Court's decision. Special leave petitions were filed before the Supreme Court challenging the decision of the High Court. The Advocate General of Tamil Nadu also filed writ petition number 93 of 1999, which the Supreme Court entertained by allowing him to intervene. Additionally, a public interest litigation was filed by an organization named Voice, which was also accepted by the court. The constitutional validity of the section 3 and 4 of the Prevention of Corruption Act 1988 and the state government's notification dated April 30, 1997 was challenged before the Supreme Court. Agreeing with the decision of the Madras High Court, the Supreme Court held the section 3 and 4 of the Act are constitutionally valid and do not violate Article 14 and 21 of the Constitution. The court also found that the power conferred by these sections were not exercised arbitrarily by the state government. The Supreme Court ruled that the notification issued by the state government dated April 30, 1997 was lawful, reasonable and valid. On the other hand, the central government failed to justify the issuance of its notification dated February 5, 1999, which was therefore held to be invalid and was struck down. As a result, the Supreme Court accepted the appeal filed by Vice but dismissed all other appeals. No specific order were passed in writ petition number 1993 of 1999 and 97 of 1999, and all petitions and appeals were accordingly disposed of. Legal principles laid down. The Prevention of Corruption Act 1988 is a special statute enacted to ensure the speedy and effective trial of corruption-related cases involving public servants. The Act provides for the establishment of special courts and the appointment of the special judges for conduct day-to-day trials of such cases, thereby enhancing the transparency, timelines, and fairness of the judicial process. Please watch full video, share and subscribe to the channel. Thank you.